learned judges, distinguished professors, my very handsome ambassadorial colleagues as well, and diplomatic colleagues, friends, one and all, and a very, very warm welcome to the Australian residents, to my home. Now, someone before said, Ambassador, I've been to a few of your book launches over the last couple of years. Now, why would that be? Why do you have book launches?
Just reputation.
Well, Professor McCormack is right. You see, people think Australia is all about koalas and kangaroos and cricket and beaches and bright sunshine. But we do read books, don't we? We do read books in Australia, particularly, ladies and gentlemen, important books. Particularly important books. Such as the one I hold in my hand, published by a venerable and illustrious publisher, Oxford University Press. A book about, as my wonderful, where is she? My wonderful legal advisor, Christine Nguyen, reminded me before, a really important and emerging topic about environmental degradation, both during and indeed after armed conflict. This is an emerging and terribly important issue. Now, just in terms of the order of proceedings tonight, we have 4 wonderful speakers, and we'll be kicked off by Professor Carsten Stahn. And you all know Carsten. He's, in fact, I was just thinking, Carsten, you have written more books than I have read. So you are prolific, prodigious, illustrious, and very influential. So it is good to see you again, sir. It's wonderful to see you. And Ambassador Marie Jacobsson, who is I think the principal legal advisor to the Swedish Ministry of Foreign Affairs, distinguished diplomat and lawyer. Marie, welcome. And then 2 Australians, a mate of mine, Professor Tim McCormack, who is a Professor of Law at Melbourne University, specialising in international humanitarian law. Tim is always very, very welcome in this residence because he is the best dinner guest you'll ever find, let me tell you. Tim, a very warm welcome to you. And of course, John Hocking, the distinguished Registrar of the International Criminal Tribunal for the former Yugoslavia. John, it is great to have you here this evening. Ladies and gentlemen, look, have a great night. It is wonderful to see so many of you. It really is. I am delighted that you've come along to my place tonight. With that, can I please ask you to welcome Professor Carsten Stahn.
Your Excellency, Ambassador, thanks so much for being here, dear colleagues and friends. It's a great pleasure, I think, to be here tonight and to have really, I think, a dream team of speakers and guests here. We couldn't have wished, I think, for a better turnout. First of all, thanks to you, Ambassador, for your gratitude of hosting, and Christina, who's been instrumental as well in setting this up, and your team has just been excellent, just to mention that. Ambassador, you've started a wonderful tradition of hosting book launches here, always inspiring discussions on new works. And it's always been a highlight in the fall to come here and to attend some of your events. And we have such a wonderful panel, of course, Ambassador Marie Jacobsson, the former ILC Special Rapporteur on Environment and Armed Conflict, who I would have to say has been really part of the inspiration for the book that we see being launched tonight. Then, of course, the wonderful Tim McCormack, who launched a book on the Australian war crimes trials last year and who set so many important footprints through his work on international humanitarian law and international criminal law. And, of course, Registrar John Hocking, who has seen many aspects of the law come to practice at the tribunal over past 2 decades, John, right? So it's also wonderful that we have some of the contributors to the book here. Simi Pine, who's just here next to David Karen, and Daniela Dunn. So, and many of the contributors are here with us tonight in spirit. So you might wonder, how did the idea for this launch emerge? Was it a long plan? Was there a specific agenda behind it? The agenda behind it was a lunch meeting, Ambassador, that we had at the Hague Academy, where we talked about the topic, and I was so pleased to see that you were so enthusiastic when you heard that this was the topic of the book and that you kindly agreed to host the launch here. Of course, it couldn't be more timely. The Bonn conference is taking place just right now. The International Law Commission has decided to continue its study on the protection of environment in relation to armed conflict. The ICC prosecutor announced last year that the OTP would provide a particular consideration to prosecuting Rome Statute crimes that relate to the destruction of the environment. So I won't say much about the book. It's part of a 5-year project that we have been conducting. It's a relatively novel topic, Jus Post Bellum, the law governing transitions from conflict to peace. And I have to admit, originally environment wasn't our focal point. But when Marie Jacobsson started her pioneering work as ILC Special Rapporteur, we immediately knew that this is the area that we need to focus on. And one of the major achievements, I think, of past decades is that the environment is not only protected indirectly, namely as civilian object or resource, but directly as a system. And in this book, we've tried to set this protection into context. So the book tries to make a case that many challenges can only be addressed through the complementarity of different branches of law, such as environmental law, UN law, international humanitarian law, international criminal law, disarmament, and human rights law. And here's also the connection, I think, to Australia on the topic of complementarity. We're very lucky that Marie Jacobsson's third report actually specified concrete principles relating to post-conflict settings and peace building more generally. The principles break new ground in several fields. They first of all acknowledge that peacetime conflict and post-conflict are not easily separable, but they're really often part of a continuum. They follow to some extent the important dictum with which many people in this room will be familiar, the Tadeusz dictum. What is inhumane in international wars cannot be but inhumane and inadmissible in civil war. They also apply to non-state actors. So we engage with some of these developments in the book. So the book shows that there are maybe 5 principles from Jus Post Bellum scholarship that relate to future debates. They are, first of all, the imperative for responsible planning. Secondly, pragmatic limitation, conciliation, burden sharing, and a care-based approach towards responsibility. All of these issues will require further attention in future years, but I think the good news is that the linkages between the needs of people and the needs of the environment are becoming ever more clear, and that there's now a body of scholarship and practice to guide the law and the choices of the future. So with this, I would like to thank our honorary speakers to speak to the book, and I would first of all like to give the floor to Ambassador Marie Jacobsson. Thanks so much.
So, thank you very much, Carsten. Your Excellency Ambassador Brett Mason, Your Excellencies in the room, and dear colleagues and friends. It is really a great pleasure to take the floor here today, and I'm very honored to have been invited. And it's the first time I see the book in real life. I have seen, of course, it in a digital version before, but it's always a difference to have it, to hold a book in your hand. Now, let me say that the Jus Post Bellum project is both groundbreaking and somewhat controversial. The reasons are 2. First, it is still provoking to some lawyers to combine, and please note that I don't say mix, law and justice. Just wars are not necessarily legal wars, as you all know, as an example. If we then add sustainability to the melange, it simply becomes too much for some. Second, international law does not recognize such a thing as Jus Post Bellum as a special branch of international law, because international law is still based on a very binary perception. Either there is no armed conflict or there is an armed conflict. It's a question of peace or it's a question of war. Hence, we apply peacetime law or we apply the law of armed conflict. But the reality is, as we all know, a little bit more complicated. And this means that also the law is not as binary as it used to be. So even if the jus ad bellum rules and the jus in bello rules still may carry with it responsibility and liability, it does not repair the situation on the ground, that is, the environment. We also know that, and I will quote from the book, the acceptance of specific ecological obligations and procedures in post-conflict environments continue to counter resistance. And this book is exactly about this. For many years, this project has updated and the Jus Post Bellum has updated and further enlightened practitioners and researchers on the theoretical framework on practical consequences of Jus Post Bellum and its link to sustainable peace. But it is not until now that the project has addressed the environment and the exploitation of natural resources as the center of its attention. In this volume, Karsten Stan, Jens Iversen, and Jennifer Easterday, and Jennifer is not here today, which is a little bit regrettable, but they have chosen to focus on environmental protection as the most visible part of Jus Post Bellum. This is an important book, and it's a welcome choice, and it's a very well composed book as well. Not only is post-bellum environmental protection a conditio sine qua non for the rebuilding of a war-torn society, it is still an overlooked matter and only occasionally dealt with by international community and then on a case-by-case basis. And UNEP, or the UN Environment as it's now called, is doing a great job here. In an attempt to corroborate the post-war environmental protection, this is not solely a policy matter, but also a legal matter. A seminar was arranged here in The Hague by Karsten and his friends and colleagues in 2014. This volume that you see here is part of the further elaboration of the research presented there, but it also contains more recent research that assists us and deepen our understanding of this complex issue. And you should note that every single article is built on an impressive amount of research. So the result is, as I said, a comprehensive and impressive volume that presents up-to-date research and comments on environmental protection of Jus Post Bellum. It is fair to say that this book is the first of its kind. It is needed and it is welcome. You heard, and some of you perhaps already know, that I was the Special Rapporteur for the protection of the environment in relation to armed conflict for 3 or 4 years. I have finished my term with the ILC because I didn't run for a third term, and the ILC has decided to continue with the topic. But let me just give you a very, very brief note on the background, why the ILC placed it on its agenda. And it placed it there because the mandate of the ILC also allows the ILC to address issues that are of pressing concern for the international community as a whole. So this was one of the reasons. In addressing environmental protection in relation to armed conflict, pre- and post-war situations are extremely important. The post-war situation is legally complex. Matters such as establishing critical time and dates of when a situation has occurred, and responsibility and liability are of absolute crucial concern for establishing legal responsibility. I couldn't reach that far in my work. I had 18 draft principles that the Commission has addressed or will address. And it's now time for my successor, Ambassador Maja Lehto from Finland, who's appointed a special rapporteur, to take over the issue in the ILC. The good thing is that there was a debate in the ILC, on the ILC report this year in the UN General Assembly, and there is the initial resistance to the topic has faded away more and more year by year, because it is a fact that we cannot deny the effect of the environment on after an armed conflict has occurred. I don't think we will get anywhere by touching the rules that is applicable during armed conflict, but there is still so much more to do, and the book shows this. I want to conclude by saying that this is, again, I would like to repeat, this is an excellent book. It is a very important book, and I hope, Carsten, that you will continue with the Jus Post Bellum. What I would like to see in your next project is addressing issues of Jus Post Bellum, protection of the environment, of sustainable peace, but particularly from a gender perspective, because that, I think, is lacking. We have no women participating in mediation, in peaceful settlement of disputes. They are not sitting at the table when states are trying to solve their conflicts, their armed conflicts. We need the women to be more visible, but we also need an understanding of how that could be done. And with that, I thank you for your attention.
Professor Stan, Ambassador, distinguished judges, ambassadors and fellow academic colleagues, other guests, ladies and gentlemen, it's also an honour for me to be here, and especially to participate in a panel with Marie and with John, not only because of their seniority and their roles, but also because I've enjoyed long friendship with both of them. Marie I met 18 years ago, John I met 15 years ago, and it's a real thrill to be here participating with them in the launch of what I certainly agree with Marie is a wonderful, wonderful book. I'm going to start off with a personal confession. I'm not sure whether any of you are interested in taking it, but whether you feel that way or not, sort of too bad, really. As I read through selected chapters of the proofs of the book, I also, like Marie, only received the digital copy and didn't have time to read it cover to cover, not yet anyway, but I chose some key chapters. I was challenged about how narrowly I tend to think about certain issues that are relevant to my subject matter expertise. And I thought there's a particular line in this volume from one of the contributors who challenges us to remember that all aspects of international law relate to each other, particularly because of general principles. And this is really true for international humanitarian law. And one of the great privileges for me is in reading some of the chapters of the book has been the self-education exercise I've been engaged in. So I'm really grateful for that. I think the expansion of your thinking about the topics you're focusing on has to be a wonderful thing. But I think there are three key contributions that this book makes that I'd like to identify. I'm not suggesting this is exhaustive, but for me, three key things that ought to be identified, acknowledged, and celebrated. The first of them is about the understanding of the nature of the problem, and here I really agree with Marie about the novelty of the content here, and the effort that both Carsten and Jens and Jennifer have put into developing the study of this subject matter. That, of course, Marie's had a really pioneering role in as special rapporteur on the topic. Right at the start of the first chapter, the introductory chapter that the three co-editors have prepared, there's a really wonderful quote from Aldo Leopold in 1949. Please don't worry, I'm not going to give you a quote from every page of the book. It's just starting with page 1. A thing is right when it tends to preserve the integrity, stability and beauty of the biotic community. It is wrong when it tends otherwise. I thought about that. That's quite a prescient statement to make in 1949. That predates me, and there are only a few people in the room that are around back then. But if Aldo Leopold is correct, then there's a lot in the world that's wrong, isn't there? Because there is so much that tends otherwise to preserve the integrity, stability and beauty of the biotic community. What I think the three co-editors have done with their contributors that have written the subsequent chapters is to help us understand the nature of the problem, the importance of thinking about the consequences for the environment, deleterious almost always, from the conduct of armed conflict. I really appreciated the awareness of that comes from reading through this book. The concept of Jus Post Bellum has been around for a few years. Carsten and his colleagues have been at the forefront of developing the academic literature in relation to it. I again reminded myself when I read through some of these chapters that I thought very narrowly about that topic, Jus Post Bellum as the law that applies in the aftermath of an armed conflict. But the editors, the co-editors, challenge that narrow view of it and talk about a much broader concept where the Jus Post Bellum is inherently connected to the establishment of peace and has macro purposes like possibly preventing the outbreak of violence in the first place or imposing constraints on the way war is waged, despite the perhaps orthodox view of a binary nature of international law that Marie was referring to. The second great achievement, I think, here is the way that this book illustrates how international law develops. And I think that I'm going to make a bold statement about the significance of the contribution in this book. I don't think the volume just contributes to our understanding of the progressive development of the law, but I actually think this book contributes to the progressive development of the importance of environmental law and the protection of the environment and the ways in which different parts of international law have a contribution to make. So there is an acknowledgement by the co-editors that there is some uncertainty about what or how we would accurately characterise the status currently of the Jus Post Bellum. Is it a system of norms and principles? Is it a framework? Is it an interpretive device? Or is it in fact a combination of some or more of those things? I've been thinking about how our understanding of international legal regulation in respect of the environment has developed dramatically over the last 25 years. It's 25 years ago this year that the Rio Earth Summit was held, and that was a major multilateral event in acknowledgement of the importance of our protection of the environment for all of us. It was a very, very significant initiative at the time, but also an aspirational one because we're really only trying to identify what the challenges are. Think about the ways in which, as an international community, we're so much more sensitive to the importance of legal regulation in respect of the environment since then. Of course, Marie's work and the work of the ILC has been fundamental here. And the proposition, for example, that the environment ought to be considered as civilian unless it's being used for military purposes is a really significant proposition to make for those of us who are international humanitarian lawyers. In Dieter Fleck's contribution to this volume, he's listed quite a few accomplishments in his view in the way in which international law regulates the protection of the environment as demonstration of the way in which the law is evolving and progressing in this field. And one of the acknowledgements that Professor Fleck makes right at the end of his chapter is the important contribution of academics and scholars, which he says have not been the least significant in contributing to the process. And I think that Carsten and Jens and Jennifer have actually done exactly that, and I congratulate them on the significance of that contribution. But finally, the third major contribution from my perspective is really the challenge of prosecuting international crimes. As the Special Advisor to the Prosecutor of the ICC on war crimes, I'm really interested in this aspect of the book's contents. And I think what the various contributors have done is really help raise awareness of both the possibilities as well as the limitations for the prosecution of environmental crimes. There's an excellent chapter in the book by Matthew Gillett, for example, on this particular topic. He's not the only contributor that writes about it, but probably the one who focuses on it most comprehensively. International criminal law, he observes, is no panacea for environmental degradation, and of course that seems like an obvious statement. But he talks about the ways in which international criminal law could contribute to raising enforcement prospects for environmental crimes. He acknowledges jurisdictional limitations. Some courts and tribunals are restricted, both in terms of geography or temporally. And even if they had jurisdiction, there are challenges about prosecutorial choices and priorities. There's a lack of commitment at the moment in international criminal law, certainly in the Rome Statute, to hold corporations liable, and Matthew gives some very compelling examples of situations where corporations themselves have contributed to environmental crimes. But then he goes on and talks about some of the other categories of crime that do exist, and I thought this was really interesting. As a Special Advisor on war crimes, of course I'm very familiar with the limitations of the provision in Article 2B that involves the war crime of disproportionate military force, where the expected widespread, long-term and severe damage to the environment is clearly excessive relative to the expected concrete and direct military advantage to be gained. We know that these three criteria, which are all cumulative, raise the standard, make it very difficult to prosecute a crime like that. So I'd come to the subject matter of Matthew Gillett's chapter with that provision very much in mind. And Matthew, I think, has done a terrific job of explaining, well, there are some other possibilities as well as some limitations. He talks about the failure to capture or secure evidence, and here I'd acknowledge Reinhold Galmetz's excellent initiative. Reinhold's here, so he'd be happy to talk to you about this, I'm sure, to establish the Centre for Climate Crimes Analysis, to assist with the identification and gathering of information and the legal analysis of it to facilitate investigation and prosecution of climate crimes. That's a great initiative. Matthew Gillett looks at genocide, at crimes against humanity and war crimes, and points out some of the possibilities for the prosecution of climate crimes in each of those categories of crime, but also some of the major limitations. And I won't go into the details of that, but I found that really fascinating chapter. And I'm glad that the prosecutor of the ICC made the announcement that Carsten referred to. And I'll be certainly thinking a little bit more creatively and carefully as a consequence of my exposure to the book. I commend it to you. Congratulate the co-editors again very much.
Yesterday, orange, pink, green, purple and blue agents destroyed the forests of Vietnam, and patches of liquid rainbows from oil spills polluted the Persian Gulf. Today, skies turn white from streaks of phosphorus, and sheep turn black from clouds of soot. To prevent the spectrum of harm that may happen tomorrow, environmental damaging conflict can no longer remain in the shadows. And that is why this book is so essential. This book is a prism which takes in this rainbow of destruction and puts out a clear light towards peace. And it reminded me of something like this. I don't know if I'm the only one who recognises it. But this book, too, explores a dark side of war, which has too often remained a silent victim. And like this iconic album, it is the cohesively edited result of the contribution of different authors. But most importantly, this book too, as we've heard, is futuristic and groundbreaking. Environmental harm in war is as old as humankind, but the study of its relationship with sustainable peace in the aftermath of conflict is recent. And in this, the contribution of the book is seminal. Carsten, Jens, and Jennifer, and all the authors, give us tools to help convert natural resources from drivers of war to drivers of peace. Protecting the natural environment in and after conflict is often pushed aside by other urgent needs: saving lives, bringing food, rebuilding homes. The authors bring it back from the periphery to the centre. They demonstrate that addressing environmental damage is vital, not only to meet those needs, but also to build sustainable peace. But turning natural resources into drivers of peace is no simple task. The challenges are daunting. For instance, fragmentation alone among different branches of law and many actors which protect, use or abuse the environment. This can cause gaps which expose nature to even greater risks during and after conflict. But chapter after chapter, this book also offers an alternative, a brighter viewpoint, one where multiple laws and multiple actors can actually foster greater protection of resources, border crossing by nature. The authors recognise the difficulties, but they also embrace opportunities from these complexities. The many positive examples from the book are a testament to that. Take peace agreements. Natural resources have now become a standing item in every major peace agreement. Breaking with previous practice, this recognises that natural resources that fueled conflict in the last decade can also sustain peace. It is recent but trending practice at the Security Council to give peacekeeping missions a direct role in addressing natural resources, as it did in South Sudan, DRC, CAR, Liberia, Cambodia, and Sierra Leone. Also, the UN has increasingly integrated natural resources from civil affairs to disarmament, demobilisation, and reintegration. It was ex-combatants and vulnerable populations who replanted pistachio woodlands and rehabilitated irrigation canals which were destroyed by the war in Afghanistan. And recognising that even its own peace operations may have a negative impact on the environment, the UN is greening the blue helmets, identifying, spreading, and adapting best practices. Today, Security Council commodity sanctions are no longer the only tool targeting conflict resources. Innovative multilateral mechanisms resting on due diligence, membership, and the powerful convergence of public, corporate, and social governance, be it the Kimberley process chaired by Australia this year, or the Ruggie Principles on Business and Human Rights, are also at work to curb the use of diamonds or oil or timber in financing conflict. And where competing priorities may leave the environment on the periphery, multilateral treaty bodies may come in to help. Home to half of the biodiversity of sub-Saharan Africa and the famed mountain gorillas, Virunga National Park in DRC. It also became home to refugees from the Rwandan genocide first, and then armed militias later. But the World Heritage Convention Committee stepped in to assist the Congolese authorities, and today the park lives again. And when I visited the Rwandan side of the Virunga Mountains, I met a thriving family of gorillas. And when I learned their name, I was encouraged. The rangers called them Amahoro, and Amahoro means peace. And while sustainable peace in DRC is still a work in progress, the restoration of this natural heritage seemed to me a small but still remarkable peace dividend. International, national and traditional courts and bodies of law play a fundamental role in environment protection in the transition from war to peace. In this complex patchwork of norms and mechanisms, there are challenges as there are opportunities. Forgive me, I'm biased for the opportunities. I come from the ICTY. In 2 decades, the ICTY has shown that justice is possible, even where it seemed impossible, in the face of unspeakable crimes and untouchable perpetrators. Let's take one example from the book, the prosecution of environmental damage at the ICC. The Rome Statute enables an international criminal court for the first time to prosecute environmental damage per se. While saluted, and we hear from the book, this milestone has also sparked some apprehension due to the threshold of the elements of the crime and also for its immediate applicability only to international armed conflicts. But yet again, many are seeing opportunities in the challenges. And as we've heard, Ambassador Murray Jacobsson proposed that protection could be enhanced by classifying the environment as civilian in nature. I agree with Tim McCormack's views on Matthew Gillett's chapter, where he suggested amending the Rome Statute to add a mirror provision for internal armed conflict. And while fully recognising the importance of prosecuting environmental destruction on its own merit, we must not forget that environmental harm may be prosecuted as a war crime, a crime against humanity, or even an act of genocide. And the ICC prosecutor took a first step in this direction with the al-Bashir indictment, which highlighted repeated destruction, pollution, and poisoning of communal wells as a means of carrying out genocide. The achievements of previous courts can also be a beacon to overcome present challenges. In 1998, the ICTR, the Tribunal for Rwanda, became the first international court to recognise that another silent victim of war, rape, could be an act of genocide. And in 2008, the Security Council declared that sexual violence in conflict can be a war crime, crime against humanity, an act of genocide. In less than 10 years, the once groundbreaking ICTR and ICTY judicial findings on rape had become an accepted norm. Today, rape in conflict, while still a scourge, is no longer silent or on the periphery. Ending sexual violence in conflict has become a global call that compels us all to act. Just a few more words. I know you've all been standing and probably dying to have a drink. Last few words. Future court rulings finding that the destruction of the environment can be a war crime, crime against humanity, or even an act of genocide might help contribute to policy making, raise global awareness, and replace the silence. And perhaps this new discourse will help us recognise the wisdom of Tadic 22 years ago. As we heard, what is inhumane and consequently prescribed in international wars cannot but be an inhumane and inadmissible in civil strife. And this also holds true for environmental harm in war. And when that happens, perhaps we will remember that Australia had already recognised this back in 1975 as it advocated for the prohibition of environmental destruction in non-international armed conflict in the negotiations for Additional Protocol 2. Binding peace agreements, multiple regulatory frameworks, coalitions of the willing, raising awareness and global and local justice. Environmental protection for peace is no longer a question of should we, it's a question of how should we. Yes, there are gaps. Yes, there are overlaps. Yes, there are questions to be addressed. But these challenges are an opportunity for all of us, academics, practitioners, states and civil society, to work together in the most synergetic manner possible, each with our strength, each towards a shared interest, so that natural resources that have driven war can start driving peace. And this book helps us to do precisely that. Thank you very much, Carsten. Thank you, Ambassador. Thank you all.